Okay, I'm going to kick things off. We have a lot to cover this afternoon, and we're also recording the session. So if folks have to pop off or join late, you can find the video after the webinar available on our website, VicenteLLP.com. I want to welcome everybody to Asset Light Strategies to Boost Cannabis Business Growth, our very short title for this afternoon's presentation. I'm Cassia Furman, a partner at Vicente LLP. I manage the firm's Los Angeles office and California practice group. And with me today are my two esteemed partners, David Kramer and Sahar Anasazian. Welcome. We all work together in the LA office, despite being in different places today. And we have the opportunity to collaborate extensively on this topic and have done so for the past many years. And it's a topic that's we're very passionate about. So excited to present some insights and have some conversation today about this topic. We will, if you have questions, please do enter them. If we have time at the end of the session, we will get to as many as we can. Next slide, Key. All right, what is the asset light model? What are we talking about today? Well, it is exactly what it sounds. It's any scheme and structure specifically in the cannabis industry in this context to use contractual arrangements to minimize assets from real estate to cannabis products and other materials to perhaps even licenses and equipment. All those could be deemed assets that are costly and challenging in our regulatory environment on a state-by-state basis to obtain. And so increasingly, as legalization has become more prevalent on a state-by-state basis, going back to 2014 through today, for adult use, that is, we've seen the asset light model become more prevalent and grow and expand throughout the markets that we work within in Vicente. And it's something that we talk with our clients about all the time. Help them strategize, help them navigate. And so today we wanted to set some of that context for you and have a conversation ourselves. So the why of why we're talking about this today, I think in 2023, it's extremely relevant to have this discussion, in particular, given two driving factors: license scarcity across all markets, even in states like California that are ostensibly open licensing models. In those states, we tend to also see strong local control, which mitigates, and minimizes the number of licenses that are available typically. So we have an environment of license scarcity, as well as sort of an immature supply chain, an incomplete supply chain in many cases, plus high costs. And those factors together combine to make an environment where it can be very difficult to get products to market, which I don't think is a surprise to anybody listening today. On top of that, added to the why, startup and ongoing operational costs and expenditures in the industry exceed those of a regular CPG model significantly, in some cases tenfold. The cost of regulatory compliance, taxes, both at the local and state level, and all of the other things, 280E, that go into making cannabis so expensive, contributes to this interest in an asset-light model. We also see, which is kind of unique from the 2023 perspective, at this point, something of a history of failed startups and underutilized facilities, particularly in states like Colorado, California, places where their legalization has been around for a while. And when the doors opened for adult use, companies did make significant expenditures in infrastructure, particularly when you're talking about cultivation and manufacturing build-outs, but also, expensive long-term leases for retail that might be in prime commercial real estate markets. And you've seen, due to the lack of access of capital, which we're going to talk a lot about to get today as a mitigating factor for the scarcity of licenses. We also have an environment where licenses have been issued, there's often facilities that are being underutilized. Either an operator might be using one of 4 licenses, or they might be in the midst of winding down operations and going out of business and looking for ways that they can bring additional revenue under their roof. Landlords as well are getting creative, given sort of lease defaults, and going out and trying to find ways that they can bring people into the facility and generate revenue. However, it can be really difficult to impossible to either issue new licenses to a facility or transfer them. And even if it is possible, it's often a lengthy amount of time. Like in California, if we want to transfer, go through a whole new license transfer process, it's going to require the issuance of a new license at the state level, unless you take over the operating entity itself, which may have significant tax liabilities, et cetera. So if that's not viable, you could be looking at up to a year or more to be able to transfer that license, fully at the local and state level into your own name. And in that interim period of time, how are you or the existing operator going to generate revenue off the license? The asset light model could be part of that equation. Next slide, Guy. So when we talk about the asset light model, there's lots of different things, lots of buckets that this could encompass. And, we work frequently across all of these areas. And one of the things that we were joking about when we were preparing for this presentation is naming conventions, and how people will kind of die on the hill that a management agreement is different from a consulting agreement or a services agreement. And we'll get often when we are negotiating these things, a lot of pushback on the title of the document, et cetera. And we tend ourselves not to be that focused on the title, because it's just, at the end of the day, they're all contracts and all contractual relationships. And although on a state-by-state basis, there might be reasons for particular naming conventions or structures given regulatory considerations. For example, in California, I structure most of our co-packing or white labeling agreements as just a generic intellectual property licensing agreement, even if the terms are much more similar to co-packing, because for years, the California regulations reference specifically intellectual property licensing as a viable means for an ancillary company to do business with a licensee. Notwithstanding those regulatory considerations, all of these things are kind of different ways to get at the same thing, which is not having a cannabis license yourself in a particular state market, but participating in the industry from an ancillary perspective. And that's the case even if you have a very close working relationship with an operator, such as a management contract. That's our first category. And these can have different names. We used to call them managed services agreements, so they sounded less like management contracts. But essentially, that model is an individual or a group going into a licensed facility and utilizing all or a portion of that license for their own brand's activities or their own company's activities. So you still have the licensee in place, that can't change, but you have another operator coming in and managing the facility or managing some component of the facility. And we often see multiple managers or consultants on licenses in California. In other states, it can be more limited. So that's sort of one asset light model. And it's, important to note too, that in the management agreement structure, it's often a licensee who has other facilities who are coming in and entering into these structures because they want to expand even within a state market. So we're not completely, asset free, but it's also used as an expansion model for licensees. The second general bucket here, IP licensing agreements. This covers, everything from sort of a traditional white label model in the consumer packaged goods world to various types of co-packing arrangements and packaging agreements, I would say. tend to sort of fall under this this sort of general frame too. And we'll talk at length about how these work and all the different iterations of them, because there are also many in this category in cannabis, and a lot of the differences between them relate mainly to payment structures. But at the end of the day, they are all one company, the licensee, manufacturing goods with some level of control from an ILP licensor who's the brand entity. And then there's a few other categories that we see frequently, both in California and on a nationwide basis. And I kind of lump these all into the platform or tech platform categories, which I sort of think of personally as anybody who's using the internet and who's not licensed, but who sets up some type of platform to host, anything from data, like packaging and availability, to fulfillment, marketing and advertisement, sometimes direct sales. There's lots of different models, both geared specifically towards the cannabis industry, and something as ancillary as an influencer that might have a link on their personal, Instagram page or, branding page to a dispensary or product line. Those are all kind of in the platform agreement buckets. And then finally, the brokerage bucket is, anybody who's not licensed themselves, who's facilitating sales amongst other parties. And these types of agreements, implicate disclosure and commissions, that sort of thing. And with that, next slide, Guy. I'm going to turn it over to David to walk us through the building blocks of the asset light model.
Thanks, Cassia. Hey, everybody. Thanks for joining today. We're wanting to talk through, for the next part of this presentation, what these agreements really entail, the meat and potatoes, if you will, of these agreements. So I'm going to start at the beginning of sort of some broad level considerations that we regularly have to think about for our clients, or they ask us to help them sort of strategize about. And then the next phase of this presentation will be to actually talk about some contractual provisions that we are very often called upon to sort of incorporate into these agreements. Before I do any of that, I wanted to just sort of build on what Cassia said, which is this whole topic of asset-light models is something that we are increasingly seeing, and really have been seeing for the last year and a half or 2 years, as capital has dried up in the space. And as a firm, and really the three people presenting on this presentation, we regularly work on both sides of these agreements. So sometimes we represent the licensed entities, meaning the manufacturers, who want people to come into their facilities because they're either sitting dormant or they want to pick up some increased revenue from people coming into their facilities. And on the flip side, we regularly work with brands or IP holders that don't want to get a cannabis license. They just want to sort of hit the market quickly and cheaply. So keep that in mind as we sort of go through the next part of this presentation. I'll try to, where applicable, talk about what provision or what topic is more germane to which side of the coin, because we really represent both sides. So with that little introduction in mind, the building blocks of an asset-light model. First and foremost, if you're a brand, you have to find the right partner. Where is the manufacturer based? If you're in Northern California, having a manufacturer out in Desert Hot Springs might not be that helpful to you. You want to also make sure that the manufacturing partner has the capability, the know-how, maybe he's in a favorable tax jurisdiction. All of those sorts of considerations are applicable to finding the right partner. And then similarly, finding the right arrangement. Is this really just an IP licensing deal? In which case the manufacturer is going to pull the levers on the machine just using your IP and your specifications? Or on the flip side, do you want to, as the brand, put your folks in the facility and have them run the actual operations under someone else's license? Again, without giving legal advice on a call that can span multiple jurisdictions and states, suffice it to say, these are different considerations you have to think about depending on your business and depending on what jurisdiction you find yourself. The next block on this slide is about brand and brand protection. We're going to talk at the end of this presentation about some more specific IP protections that brands really ask us to sort of think about in connection with these relationships. But suffice it to say that for now, if you're a brand, the most important thing you have is your IP, your specifications, your branding guidelines, your trademarks, your trade secrets, right? Coca-Cola does not let everyone have access to their famous recipe. Maybe no one on the phone is yet Coca-Cola, but we all hope and aspire to get there. And so how you protect your IP, how you limit access to your IP are all very, very critical as you start thinking about these relationships. And again, we'll return to that at the end of this presentation. Licensor non-cannabis materials. This really pertains to sort of sourcing generally. As you enter into these relationships, we all know that if you're not a cannabis licensed entity, you cannot touch cannabis in any market. But beyond that, what if you are a gummy manufacturer and you need sugar, or you're a chocolate manufacturer and you need chocolate, and there's or packaging. There's all sorts of non-cannabis materials that go into all of the products that everyone on this listening in, I'm sure, has to source. So who you're sourcing from, who between the brand and the manufacturer is responsible for picking up those non-cannabis materials, for paying for them, for the terms and conditions with those suppliers. Those are all sorts of things that people like to think about upfront. I will say that by and large, for non-cannabis materials, we often see the brand, meaning the non-cannabis licensed entity, responsible for those non-cannabis inputs, but not always. And there are reasons for why it would or why it would not be the case. So that's another consideration. Moving on to the sort of the second row on the slide, advertising and marketing campaigns. This is another area that comes up all the time between the brand and the manufacturer, which is the manufacturer, as between the manufacturer and the brand, is the only one that is typically regulated by the state. In California, for example, the DCC doesn't really have its tentacles around brands, although there are some things they can do. And so ultimately, it's the manufacturer that has regulatory responsibility and compliance responsibility for the brand's underlying brand's marketing. But of course, the brand, especially if it's a big brand, is going to want to have a say on all marketing decisions and advertising decisions. So how you sort of navigate that water and who's responsible ultimately for what from a contractual perspective is very important. I would say the most common iteration we see is the underlying brand will produce the copy and the billboards and what have you, but ultimate responsibility for that vests and lies with the manufacturer. So manufacturers often will ask for indemnities and reps and warrants from the brand to make sure that if the brand steps out of bounds, they're paying the manufacturer for it. And again, we'll come to a little more about that in a moment. Supply chain block and tackle. Similarly to the advertising piece, this is about brand ambassadors and who's responsible for sales and who can control the sales. Again, similar to sourcing cannabis materials, ultimately the licensee is the one that has to conduct the sales. We can't have unlicensed brands in California, for example, conducting sales. That's a big no-no. But who's actually out in the field, the order, if the sales are done under the licensee's metric account, that's another sort of issue and something to think through that we're very often called upon to write out in these agreements. We all know that putting resources into sales is hugely important, especially given the market saturation and concentration in places like California. So this is another area that gets heavily negotiated. And then finally, a multi-state development plan. A lot of clients, especially clients that are constantly looking east and in the Midwest as those markets expand, are trying to find partners that can fulfill their orders and manufacturing needs. I mean, one partner in multiple states. So if that's something you're looking at, that's a big consideration for people. Alternatively, if you're trying to stay local and build your brand on a hyper-local basis, that might be less of a concern. Related to this point, we are often asked by clients, hey, we want one template, one form that can work in every state. That's an attorney's worst nightmare. Because in this highly regulated industry, every state has different regulatory considerations. In some states, like New Jersey, I believe, you have to get a managed services agreement pre-cleared by the New Jersey regulators. In California, you don't. You might have to disclose the agreement, depending on how much control the brand has over the licensee. But you can see how those sorts of things would result in different agreements, different templates. And so while we very often get that ask and are able to use sort of the same skeleton, the same frame for multiple jurisdictions, every state's going to have different specific requirements. So these are the building blocks. I want to, if we can go to the next slide, please, I want to talk through some of the minutia that come up in every one of these agreements, regardless of whether it's a management agreement, an IP licensing agreement, a platform agreement, or any agreement by a similar name. First and foremost, the economics, right? That's really the key. So, most common, most typical in a licensing agreement, there's some sort of revenue share or royalty whereby the manufacturer is getting X% of the sales and the brand is getting Y. And we see a wild a range of what that X and Y can be. I'm not going to divulge any specifics on this webinar in public, but suffice to say it goes, it ranges quite significantly, and there really isn't a market. We get asked about market all the time. I think in the non-cannabis world, somewhere between 10 and 15% of the brand is quite normal. We see those numbers a lot in cannabis too, but we very often see numbers that are quite different than that. In a management agreement, especially if the service operator is coming into the facility and really running the entire facility, the economics might look quite different, because effectively the service operator is running the entire operation in exchange for either a flat fee or sometimes a percentage of revenue back to the license holder. And again, these are very heavily negotiated deal points between the parties that we are often called upon to assist with. The next tile on the screen, the extent of operational control, is similar to something I alluded to before. Is the brand coming into the manufacturer's facility and pulling the levers, bringing its own people and really running the entirety of the operations? Or is it more of a straight licensing deal where the brand says, hey, here are my marks, here are my specifications, but I want you, the manufacturer, to handle everything? And the answer to that question varies considerably from state to state, depending on what the regulations will allow and what disclosures are required. And Sahar is going to talk about that in a few moments, so I'm not going to get into any more detail just yet, other than to say this is a huge issue that comes up in every single contract we do in this space. As the next in California, the preference from a regulatory perspective, and I think there's a sound basis for this in the regs, is for the license holder to actually control the funds, meaning when there's a sale made, the funds flow to the license holder. There are instances, and there are some folks that don't necessarily read the regs that way. I'm not going to get into a legal issue per se on this call, other than to say who controls the funds obviously has huge implications on leverage, negotiating power, and of course, what happens if things go south. The next tile, protecting IP and confidentiality. Again, we sort of talked about that. I talked about that for a moment, about how you do that, what that looks like, and we will spend a good 5 minutes on that at the end of this, so I'll come back to that. The red tile in the bottom left, employer and employee relationship. So in California is a little different than a lot of other states in this regard. In California, there are very few facility workers who actually have to be employed by the license holder. The exception to that in California are delivery drivers for delivery licenses and truck drivers for distribution licenses. Other than that, in the eyes of the state, they don't really care if the person pulling a lever on a machine is employed by the brand or the manufacturer. And so that goes back to who's actually controlling the operations and what are the regulatory considerations of who's controlling those operations. Other states, by the way, have much more onerous views of that and require anyone working in the facility to actually be employed by or badged by the license holder. And so again, every jurisdiction is going to have a little bit of a different view on who actually has to employ the workers. The next tile is probably my favorite topic, which are tax issues arising from these sorts of relationships. And when I talk about tax issues, there are really two main buckets. One is who between the brand and the manufacturer is responsible for collecting and remitting excise taxes and other sort of cannabis specific taxes that come up in these relationships. And the second bucket of taxes is what happens if revenue gets reported, or the brand's revenue gets reported on the licensee's books. And now as a result of the brand's activity, the licensee has to report increased income tax liability on a federal or state level. To the untrained eye and to the untrained operator, they're not thinking about these issues. And the result can be that the brand is saddling the license holder with massive tax liabilities. And we actually saw this play out in the first few years of legalization in California. Without mentioning any names, there were a couple of companies that were walking into and operating licensed facilities. The licensee didn't think to negotiate around this point. They turned around 2 years later and they had massive 280E tax liabilities as a result. And it's been a mess, and it really broke a lot of companies as a result. So this is increasingly becoming an issue people are aware of. It's increasingly becoming an issue that people are contracting around and indemnifying for. And for me, it's sort of top of mind and focus as we enter into these agreements. The last two tiles on this slide before I turn it over to Sahar, we've got term and termination. That one's easy. How long are these agreements for? What sort of outs do each party have if the relationship goes south or if one party is in breach? For example, if we're in a situation where the non-licensed entity is really running a licensed entity's facility, and the non-licensed entity causes the licensed entity's license to lapse or be revoked, that would be a big problem for the licensed entity, and the licensed entity would want to obviously have termination rights and, of course, some sort of indemnity back from the brand, if you will. And then the last one is about risk allocation. I've mentioned indemnities and reps a few times. I could spend a lot of time talking about that, but suffice it to say, both sides this is a very heavily negotiated deal point. Both sides want the other party to be repping to the fact that they will be complying with all applicable law, that they'll be maintaining the licenses in good standing, things of that nature. Insurance is another big one. The brand getting added as an additional insured on the licensee's insurance, and or vice versa, depending on the scenario. And then, of course, liability caps, making sure that, for example, a licensee's liability is capped at a certain dollar amount. Often it's some multiple of the total royalties received from the brand. So again, I could speak about this at length, but these are just some sort of highlights that I wanted to start with as far as the key considerations to be thinking about.
Thanks, David. So now that we have an understanding of what the considerations here are, why we would consider entering into these kinds of relationships versus getting licenses, we turn to the benefits of why somebody would want to do this. And one of the key benefits here is that there are less upfront costs usually associated with the asset light model. So whereas pulling a license would require finding space, securing that space, whether it's through leasing or through purchasing the space, getting a license in certain jurisdictions like California, that may require getting a local license as well as a state license. In other jurisdictions, it might be a highly competitive license, which would mean that just putting together a license application would be costly, would be very timely. And then there's also the consideration of putting together the machinery, which can be quite costly. All of those costs will tend to add up. And as David mentioned, there's also certain tax considerations, which a little bit less upfront, but certainly a cost focus to think about. Whereas if you are going with the asset light model, your considerations really are tied to your brand, your intellectual property. Perhaps you are thinking about packaging and putting packaging together to give over to your manufacturer. You might be thinking about ingredients, but generally your IP, your packaging, your brand, ingredients, things like that tend to be less costly than pulling a license, purchasing a license, securing real estate, securing machinery, and really putting everything together that goes into running a licensed facility. In addition to that, using the asset light model does allow for a greater focus on the brand rather than having to think about operations. So rather than thinking about how to run a licensed facility, maintaining that, having employees for that, thinking about all of the regulatory pieces that go into running a facility, having an asset light model really allows the brand to think about how is the brand going to look, how is the brand going to develop, how are product lines, for example, going to develop, what states will make sense to go into, and not really have to think as much about day-to-day operations of a facility. Not having licenses also allows for much quicker expansion. So, as mentioned, it takes a good amount of time usually to secure a license. It can take a good amount of time to find land in a properly zoned area. It can take a really long time, depending on what jurisdiction you're in, to be able to secure a license, to be able to secure even funding sometimes to get the licensure for what you need to do. Whereas with the asset light model, Usually, if you have found a partner that you're able to go in and either use their facility or contract with them to have them start creating your products, it's a much quicker way to get off the ground, depending on how long it takes for your partner to be able to start production and distribution and whatnot. Usually, though, this means that you can have products and you can have sales of the products happen much quicker. And you can do that on a state-by-state basis much quicker than you would be able to if you had to go in, again, find real estate, set up a facility, pull licenses, and set up a traditional cannabis operation. Because of all of this, the asset-light model also allows for greater flexibility and greater agility, which means that if you go into a market and it's not working out so well, generally you just end up terminating the relationships you have there. You'll end up, selling through the product via your manufacturer, your distributor, and can usually get out of that state much more easily. Whereas if you have a licensed facility in a certain state, you've already put in quite a lot of money into that. Oh, looks like we went back a slide. You've already put in quite a lot of money into that, and it's a longer process, both from the regulatory side and from the economic side, to be able to shut down production there. In the same vein, if you are finding that there's a greater demand for your products in a certain state and in a certain portion of the country, it tends to be much more easy and much more quick to expand into that portion of the country. Again, it usually is a matter of ensuring that you have good partners there, that your contracts comply with the state's needs, that your products, their packaging and your advertising comply with the state's needs. And once you have that, you generally can go into another market and start up much more quickly. The asset-light model also does create the potential for interstate commerce. Obviously, currently you can't move cannabis products across state lines, but having an asset-light model where all you have is IP rather than having to move licenses and develop new licenses does allow for potential future interstate commerce. And it also does allow for, depending on the regulations, of course, you to use your packaging and certain non-cannabis products throughout the various portions of the country that you seek to be inside. And that, I'm ready for the next slide, complications.
Okay, thanks, Sahar. I'm going to take back over. We were joking when we put together the outline that we only had one slide for the benefits of the asset-light model, but 2 slides for complications. And we don't say that to scare people away from setting up the model. I think it's somewhat imperative for at least brands, if not the manufacturing and licensee side of the cannabis industry, to consider this model in 2023 and beyond. It's more so that we as attorneys are often involved in the sticky wickets, if you will, of these relationships, and the benefits somewhat speak for themselves, whereas the complications, the kind of potential pitfalls, can be slightly more difficult to contemplate before you start getting involved in these things. But we've been on the other side with our valued clients and colleagues many times, so have seen the start and the end of these relationships. So it's natural for us to focus a bit on that, because the more that you can plan for risk and allocate it to the best of your ability at the beginning of a relationship, obviously the fewer issues prospectively when the relationships terminate. And as discussed, the sort of beauty and the efficiency of these models is that they can be turned on and off much easier than the cost of obtaining and time of obtaining a license. But there's still complex contracts that require careful considerations and a wind down period when they end, etc. So I'm here to talk a little bit about the things that you might want to consider as you look at different markets, look at different partners, etc. First, supply chain inefficiencies. And this is This is targeted somewhat towards the brand side of the asset light equation, but also applies to wholesalers, manufacturers, other people that might be interested in co-packing and trying to get into this space. What we've seen as an area of complication for these models are delays both in the movement of products and money through the supply chains. In a traditional intellectual property model, for example, typically the brand kind of sits back after they license their IP and gets, a bag of money at the end of the day, hopefully, if it's a successful relationship, a revenue share with the licensee. And what we've observed in the cannabis industry and work on is that because the supply chains, particularly in non-vertically integrated states, tend to be less than highly functional, to put it kindly, there's a lot of constrictions and pressures in different areas that compel a brand as well as their partner to have to work extra hard to actually bring these products to market. So that is not one of the big issues, obviously, which we hear so much about in California, but is also an issue in other states, is the debt balloon, the debt crisis in the cannabis industry. Nobody's getting paid, everybody's being slow paid, and it's just ballooned into being a bigger and bigger problem since 2018 when licensing began. And I won't get into the whole host of reasons behind that. That would be hours more discussion, but brands in these models do tend to be paid last and cover a lot of upfront costs. So you need to build that into your model. And if you're a licensee, if you're the co-packer, you'd be well within your grounds as a responsible operator to require payment of as much as you can up front, because the payment coming back from the retailer through however many steps of the supply chain back to the licensee manufacturer and then ultimately to the brand itself can take a really long time, and not providing for that in your pro formas and your build out models can make these situations quite difficult. Similarly, sourcing materials, particularly the cannabis materials, the raw inputs, and finding a consistent quality, particularly with packaged flower. And flower products like pre-rolls is often an issue across multiple markets. It's an issue everywhere, seemingly perennially. And then, going back to the focus on the brand and the difference between, a traditional CPG IP licensing model where, I have a cool popcorn brand that I'm going to hire, company X to white label it for me, and then I'm just going to sell it wherever I want. This is sort of the opposite, where just because you have a manufacturer to produce the products isn't the end of your day. We're often seeing companies have brands, I should say, having multiple licenses of their intellectual property to different steps in the supply chain to get their products to market. So, because we're in California using that model, I've seen some brands have to, license their IP, because that's kind of the sanctioned model of working with licensees, to a cultivator to secure the product. Sometimes, they can just arrange the direct sale that's then facilitated by the co-packer. But if they want to have more control over the cultivation side, there might be a separate sort of IP license and agreement as to how the materials will be grown. There's the license with the manufacturer itself. And then they might need to have a separate distribution agreement, notwithstanding a brand ambassador activity to actually get the products to market. And the reality of us being in a very new marketplace is that, none of these processes are, and many of these businesses are not really structured to actually make direct sales. There are some exceptions to that. There's some distributors and other manufacturers that focus more on a house of brands concept. So they're willing to offer those, full suite services to brands that want to come in and license their IP. But more often, the reality is that the brand is kind of doing all this work themselves. We talked a lot about regulatory changes, so I'll move on to the regulatory challenges. So I'll move on to the next slide, please, Guy. Yeah, regulatory liability and liability shifting. What I will say about this is it's a complicated area, and the title and ultimate responsibility for the products in the eyes of the cannabis regulators lies with the actual producer of the product and not with the brand. And that's true from both the regulatory compliance perspective as well as product liability. And that's sometimes really difficult for parties to reach accommodation on. Often sort of people getting into the space from a manufacturing perspective don't necessarily realize that. And a lot of times the brands don't either, but it's a really significant consideration that's part of these equations. So if you're a manufacturer who's white labeling products, like in the eyes of the regulators, those are your products, not brand X. So you have to keep that in mind. Title is another big one. It's a hot potato. Nobody wants to take title to these products, and the brands can never take title if they're not licensed. And so negotiating who's going to take title and when and who's going to bear the risk of loss is often not something that the parties really want to spend time on at the beginning of the relationship, but can become a huge issue later on. Exit considerations, just wanted to highlight here that the sale of, a right to, have my products manufactured in New Jersey is certainly not as valuable as having a license in that state, and also typically requires the consent of the licensed party to sign off on, because there'll be assignment clauses, et cetera, that require consent. And then insurance limitations. If you're a brand, there's no real effective product liability products that are out there in the market. And so you're going to have to work with your licensed partner to try to get the best coverage that they can. It's very expensive, and nobody's ever happy about that. So next slide.
So now that we understand some of the positives, some of the negatives, it's important to think really about the regulatory constraints that are associated with the asset-light model, given that cannabis is a highly, highly regulated industry. Even though the majority of the tentacles of the regulators tends to usually reach the licensees, the manufacturers here, it's still very, very important to think about how the overall regulatory model will affect the ability to use the asset-light model and how it varies from state to state. So as we all know, cannabis currently really is a patchwork of state to state regulations, meaning that certain states will allow for the IP license model without too many constraints, whereas other states will require certain disclosures. And even further than that, other states will require pre-approvals or some kind of approval before things can really go underway with respect to manufacturing and sales under this model. It's also important to remember that different states will have different advertising rules, different packaging rules, as well as different rules on what kinds of products are possible. It may be that in a certain state, a brand will be able to have the exact type of advertising and the exact type of packaging and labeling that they want, and can have various different product lines ranging from flower to pre-rolls to vapes and different types of orally ingestible products and edibles. Whereas in another state, the advertising will have to be toned down, the packaging will have to be made different, the labeling will have to be different, and certain types of products will not be possible. So the difference from state to state will affect both the relationship, the timing of the rollout, as well as what the product and what the packaging and advertising will look like. So really the duration of the lifetime. It's also important to keep in mind that different states think about control differently. So certain states will have examples of what they consider control to be and who is allowed to hold that control. Usually that's the licensee, whereas other states will be more vague about what they think about what they consider control or management or direction to be. And it's kind of up to the regulators to really interpret that. So one state may allow for a more robust IP licensing agreement or managed services agreement, whereas another state will have to have that relationship be more fine-tuned with much more different and regulatorily controlled language in there. Certain states will allow for the brand to just be able to go on site and participate a little bit more on the operations as related to their product line, whereas other states will really limit how much and how involved a brand can be in the actual production itself. So we just talked about the management and control. Pre-clearance is certain states will require for the licensee, for the operator, to disclose the relationship, maybe even disclose the agreement itself, disclose who the brand and the principles behind the brand are. And once the state clears that relationship, the agreement, and maybe even the principles behind the brand, then operations can begin. Part and parcel with that will be sometimes the principles behind the brand, behind the intellectual property, will actually need to undergo background checks akin to what the principles of a licensee itself have had to go through and have had to clear. Sometimes this will depend on what the state defines an owner to be. It will depend on how much control, as that's defined by the state, is given to the brand. This may also depend on how the economic relationship breaks down. So certain states will require an entity or persons that get a certain cut, a certain percentage, certain revenue shares to undergo background checks because they are considered to be owners just by way of the economic relationship that they have with the brand. So that's also something else to consider from state to state, and how the payment model with respect to the asset light model is structured. And then also it's important to think about what different states think about ancillary companies. Certain states have rules for certain types of ancillary companies, like technology platforms, for example, but otherwise tend to be silent on intellectual property. Other states don't really regulate ancillary companies as much. And then there are states that will think about the treatment of an ancillary company on a more situational basis, depending on the exact relationship with the licensee there. So depending on a brand's desire to be disclosed, to undergo background checks, and to be more or less regulated by the regulators, it's also important to think about that ancillary company treatment on a state-by-state basis. Next slide. So really drilling down into the regulatory considerations, we're going to take a look at some case studies of how different states control or think about the asset light model and IP relationships. First state we'll look at is California. And California tends to kind of be in the middle, at least with respect to the case studies that we're looking at here. So generally, the California regulators on the state level have not required disclosure of the IP agreement itself. One of the things that really goes to the heart of what types of disclosures are necessary with respect to the asset light model for a brand will be the fee structure there. And depending on how the fee structure is made, how much of the revenues will be kicked up to the IP license holder, to the brand, how much of the overall funds that come into the licensee are kicked up to the brand. The brand and its principals may have to be disclosed as an owner, which may require background checks, or they may just have to be disclosed as a financial interest holder. California is one of the states whose regulations don't really have too much of a definition on what we think about as far as what goes into control, direction, or management. And so how much control, direction, or management is placed into the hands of the brand on a situation by situation basis may also affect what type of disclosure and what level of disclosure is required for the brand. We next.
Hey, Sahar, I just want to make one note on California, which is that the current iteration of the regulations would only require disclosure as an owner for IP licensing if you also had management and control. Otherwise, regardless of whether you exceed 20% of the profits, if you don't have ownership and control, you'd still be financial interest holder. So just like very technical thing, but that was a change in the recent regulations that a lot of people aren't aware of, I think. Go ahead. Sorry, didn't mean to interrupt.
No, thank you. And it's things like that to think about that are the nitty-gritty details of what will really affect your relationship with your operators. So the next state we're going to look at is Michigan, and Michigan tends to fall into one of the more disclosure heavy states. So Michigan requires pre-approval of this type of relationship, and generally the licensors, the IP holders, the brand is subject to disclosure. So depending on the brand's willingness to be disclosed, that's a consideration to think about before going into disclosure heavy and prior approval heavy states like Michigan. The last state we're going to look at is Arizona, which out of these three tends to fall into the more relaxed bucket. Arizona tends to have relatively relaxed requirements as far as disclosure goes. Generally, we don't see disclosure requirements of the relationship or the brand holder itself. Of course, it's important to remember that with every state, regulators tend to have pretty broad abilities to ask for additional disclosures. They tend to have broad abilities to ask to look deeper into the contract, the actualities of the relationship, as well as the brand holder. So important to keep in mind that you as a brand may be subject to additional disclosures and to additional kind of look throughs and whatnot beyond what the state's regulations say. Next slide.
Thanks, Sar. So this is going to be the last slide of the day, last substantive slide of the day. And this is what we're going to be talking about protecting your IP. And the reason we wanted to spend some time on this is regardless of which model you decide to employ, whether you're giving your IP and having someone else manufacture it, or on the other side, you're going
Hey,
to
David,
someone...
you're getting a little garbled there. Are you maybe far away from the mic or something?
I'm in the same place. And you're now okay.
I can't personally. You sound sort of like have rocks or in your voice. Maybe try again.
Any better? All right, maybe one of you can take the slide then, because I don't want to gargle my way through it.
Okay, I'm happy to do it. I'm sure I won't do as good of a job as you would, but since we can't hear you very well, yeah, I mean, this slide gets a little bit into the nuts and bolts of the agreement. And these terms are typically, I mean, I have some clients that are very focused on IP protection and great about reading the details. And, you know, quite a few other people who are very busy with other aspects of their operations and tend to not focus on this as much. But it's really significant, especially if you make a habit of trying to expand your business in this way. And I think that we can all assume that these types of protections, as well as IP enforcement in the cannabis industry, is only going to become more important the bigger your brand gets and the more, successful that you are. And there's a lot of copycat products out there. Your IP registrations at both the state level, which are typically available for cannabis products specifically, and at the federal level, which right now are only available for sort of ancillary products like soft goods, et cetera. It's still good. You should still consider pulling them so that you can start to, plant your flag at the federal, from the federal perspective on IP protection. Those registrations are really only as good as your enforcement. So that's something that a lot of brands, they go to a lot of trouble to register their marks, et cetera, but then don't actively police them. And if you fail to actively police them and try to stop people who are infringing upon them, you may end up, without the ultimate right to use them long term. So that's kind of the first aspect. Clearly describing the IP and the scope of the license is really important. I've seen many conflicts around this result where, operators and licensors are not aligned. Often people will make only a very broad statement about their marks and such without attaching any specifications or, descriptions of the marks themselves. And I think, as just a broad rule here, the more specific you are, the better the protection. We've seen this also a lot play out with genetics licensing. So, people want to license their genetics and their seeds, but they may not have patents over them. And, there's no real easy solution to that besides trying to maybe have personnel in the facility to sort of maintain on the ground control over the genetics, if that's important to you and you're in a state that it permits that. But, clearly defining what the scope is, if you want to make sure that the licensee has, you sign off on all of the, not just advertisements, but any kind of public announcements about the brand, et cetera. That's something that also often isn't stated and becomes an issue. Limiting the employees who have access. This is something I've worked with directly where, we sometimes get iterations of agreements that don't that aren't as broadly stated as they could be to apply to everyone who works at the facility, to cover employees under NDAs, to cover principals of the company if they leave that company and go to another business. You want to make sure that you are thinking about all the things that could happen with everybody who's in that facility and has access to your intellectual property, particularly if it's a unique process or formula that you are licensing to other people to make. Termination rights are a big one. Exclusivity is as well. We've seen, these agreements do tend to come and go quite frequently as people search for the right operators. And sometimes, depending on the state, it will take brands a few tries, and manufacturers, on the other hand, a few tries to kind of get the agreements right and find the right partners, et cetera. So defining, how you can get in and out of these contracts is quite important. You see everything from, a Loctite exclusive agreement to terminable at will with notice. And depending on where your interests are in the agreement, how much you have financially tied up into it, you're going to want to, focus on that in particular. And then injunctive relief. Being able to have someone actually stop, like being able to compel them to stop and cease operations if there is a problem and there is, unlawful or unauthorized use of your intellectual property is very critical. So all of these things, I guess, to conclude this slide and to conclude, this part of the presentation, since we're out of time, all of the miscellaneous provisions and contracts that people sort of gloss over and think aren't important actually are often the most important parts of the contract. And this is a lesson that both lawyers and brands need to learn again and again every day, because it's very easy to just, focus on the sort of economics and forget about the IP protections, termination clauses, and damages provisions. But they often determine the success of the brand over the course of its existence. So with that, I want to thank David and Sahar, and to Guy and our excellent team at Vicente for hosting us today. And want to thank everybody who joined. Good luck to you. We're wishing you all the best in all of your endeavors. Have a great rest of your day.
Thanks, everyone.
Take care.
Thanks.